So New York is now fighting against the request that the Supreme Court take review away from the Second Circuit and review the New York concealed carry laws right here and now. So let's talk about this. But real quick before we jump into this video, I want to thank the sponsor of this channel, which is Kershaw Knives. Kershaw manufactures close to 1 million knives in their US factory every single year. And Kershaw just dropped their new 2023 line, which includes a ton of knives that are high quality, durable, and also aesthetically pleasing. So I highly recommend you check out Kershaw Knives. I carry one of their knives every single day for my EDC. And right now, if you go to their website and order and you use the code 20Scholar, you can get 20% off of your order and free shipping on orders of $100 or more. So head on over to Kershaw Knives, use that code, and thank you again to Kershaw Knives for sponsoring this video. As I mentioned in the intro, in this video, we'll be discussing a case that is now seeking Supreme Court review, and it's requesting that the Supreme Court take the power away from the lower court, take the power away from the Second Circuit, and instead review and decide this issue now. This case we'll be discussing is called Gazzola v. Hockel. This case involves a challenge to the state of New York's new CCIA law, which they passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. This case is different from some of the other challenges that are currently going on because this one focuses on how the CCIA has a direct impact on dealers and gun stores. In this case, the plaintiffs were seeking for immediate Supreme Court review. Essentially, they were requesting that the Supreme Court bypass the lower court, but the state of New York has now submitted their arguments to the Supreme Court on why the Supreme Court should not review this case right here and now. This whole case is a result of the Supreme Court's recent decision in Bruen. In Bruen, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruen in that decision was that the government bears a burden to prove that their restrictions are based in the history and tradition of our nation. However, despite that decision, the state of New York rushed through the Concealed Carry Improvement Act, also known as the CCIA, which made the permit scheme even worse in the state of New York than the one that existed prior to Bruen. These businesses, for example, are challenging how the CCIA's regulations are currently preventing them from being able to sell firearms. They claim that their entire inventory of rifles have been trapped because of this new law. They are also challenging the CCIA's ammunition background check requirement and that whole system. And they claim that the additional restrictions are creating a situation where they are losing a ton of sales, they are being financially impacted, and also there's a huge risk of them having to shut down all these locations. The plaintiffs in this case originally filed their lawsuit back in November, and it was filed in a district court in New York. In that lawsuit, they argue that the CCIA violates various constitutional rights, including the Second, the Fifth, and the 14th Amendments, along with federal preemption. In the case, the plaintiffs sought to obtain a temporary restraining order and a preliminary injunction from the district court. However, the district court rapidly denied both the TRO and the request for a preliminary injunction. The plaintiffs then went ahead and submitted an interlocutory appeal up to the Second Circuit. The plaintiffs sought for the Second Circuit to find that the denial of the TRO and the denial of the preliminary injunction was in fact an error. They wanted the Second Circuit to find what the district court did was incorrect. However, that three-judge panel at the Second Circuit level originally denied their appeal, saying that the lower court down below did the correct thing. In response to losing at the district court level and then also initially at the Second Circuit level, the plaintiffs here decided to then go up to the Supreme Court, and they filed a writ of certiorari before judgment. This is a completely different mechanism for early Supreme Court review of a case. They are trying to leapfrog the Second Circuit and get the Supreme Court to hear this issue right here and now. This type of petition invokes the Supreme Court's statutory power to grant cert before judgments in the lower federal courts of appeals. Under Supreme Court Rule 11, the Supreme Court can, anytime before judgment, deviate from normal appellate practice to review matters of such imperative public importance as to justify immediate determination in this court. And that is what the plaintiffs are seeking here in the Gazzola case. They want to bypass the lower courts. They want to bypass those hearings and instead have the Supreme Court rule on this issue right here and now. In response to that petition, New York has now submitted their opposition to the Supreme Court, and they are fighting against the Supreme Court granting review of this case. New York, in their opposition, states, petitioners seek to halt the implementation and enforcement of these measures by the New York State Police and the State Division of Criminal Justice Services, principally claiming that some of the laws violate the Second Amendment and others are preempted by federal law. The district court denied petitioner's motion for a preliminary injunction, and an appeal from that decision is now pending before the Second Circuit. The Second Circuit heard argument in this case on March 20th, 2023. The petitioners have failed to show any reason why this court should take the extraordinary step of bypassing Court of Appeals review and granting certiorari before judgment. Indeed, petitioners have not presented any pressing issue for the court to review even in the ordinary course, nor have applicants pointed to any split in authority on the issue they raise. To the contrary, this court in Heller expressly stated that nothing in its opinion should be taken to cast doubt on laws imposing conditions and qualifications on the commercial sale of arms. Moreover, this case's interlocutory posture renders the resolution of any issues premature. The court should not grant certiorari while this case proceeds in the lower courts. So the state's arguments are essentially that this case and issue are premature at this time, and that the Supreme Court should let the Second Circuit decide the case before the Supreme Court ultimately decides if they're going to step in or not. Recently, the Second Circuit held oral arguments on 5 of these cases, which are a challenge to the CCIA. One of those cases includes the Gazzola case. The Gazzola case, initially the plaintiffs decided to seek emergency application up to the Supreme Court, and then there were some other cases like the Antioch case that tried the same thing. The Supreme Court ultimately just remanded those cases back down, or sent those cases back down to the Second Circuit, but with instructions to the Second Circuit for them to review those cases and essentially to take them serious. And if they didn't, then the Supreme Court would step in. So there is a Gazzola case that was heard before the Second Circuit, and currently we are waiting for the decisions from the Second Circuit. They also point to the fact that this case is in an interlocutory posture. The Supreme Court often does not like taking up cases at this stage of procedure, which New York is pointing out, and they're using as a way to get the Supreme Court to not want to review this case. New York goes on to argue in their response that petitioners have failed to present any issue sufficiently important to warrant certiorari before judgment. They argue that despite claims that gun stores will have to close their shops, there are still 1,700 shops operating within the state. New York also contests the claim that the plaintiffs made that if the gun stores have to adhere to the CCIA's laws, then the gun dealers will have to turn over information to the state of New York, which the state of New York will then potentially use for a gun registry. However, New York contends that there is no conflict between state law and federal law and no creation of a federal registry, and they're claiming that this is simply a way to have gun dealers, gun stores, and these states assist with background checks, and they're saying that this is not a mechanism that's going to create a registry. And based on all this, New York then requests that the Supreme Court deny cert before judgment and instead let the Second Circuit review and decide this case first before stepping in. Ultimately, I think the Supreme Court will agree and they will let the Second Circuit issue their decisions in the 5 CCIA cases. Depending on how those decisions play out, maybe then there will be a determination by the Supreme Court that they want to respond and step in. This could be something that just simply sits at the Supreme Court level until we see how the Second Circuit rules on all those 5 cases. So this is something I wanted to bring to your attention because it's a little bit different. It's interesting. And right now you at least have a case kind of waiting at the Supreme Court level and ultimately waiting to see how the Second Circuit rules. But if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.